Hello, I'm Kira Portnaya, and today I will be discussing LivingSocial's terms of service. Found on the footer of LivingSocial.com and entitled Terms and Conditions, LivingSocial presents 24 clauses that constitute an agreement that any user of the service accepts just by using the service, whether on its website, LivingSocial.com, its associated mobile app, or its other touch points, ambiguously defined in the contract as merchant specific, city specific, or other area specific versions or sections. In fact, the terms specifically state by using the site and or service, you agree to these terms and refer to these terms as a legal binding agreement. However, users, when they visit Living Social, register for Living Social, or even when they buy a deal, are never prompted to agree or even read the terms and conditions. The fact that it's even there and available on the site is only common knowledge, as most internet savvy users know that most sites do provide them. But most internet savvy users or not don't ever actually read them. The fact that Living Social expects this document to represent something of a legal contract is actually conflicting with a usual understanding of a contract, where both sides assent to its terms. In fact, while click wrap agreements do hold up in court as a legally binding document, assessing that a user is given a fair chance to read and make a physical gesture, such as clicking on the I agree button, to consent, browse wrap agreements, such as the one Living Social has, do not give users that chance. Browse wrap agreements, where users have to literally browse the website to find a link to the terms and conditions, are unfair to users, according to Ed Bailey, writer for the Electronic Frontier Foundation. And courts may find it unreasonable for users to know that it's even there, especially as it contradicts normal web users' behavior. However, for a company that has seen more than its fair share of community scrutiny in the last several years for reasons such as unfair return policies and bad customer service, its terms of services as a whole is, for the most part, except with only a couple of exceptions, a very fair document that gives its users a lot more power and less obligations than to some other comparable companies. Speaking of obligations, here is what is expected of Living Social's users. Section 4 places the following conditions on the use of service. Users must be at least 18 years old, they must comply with the terms of this document, and must be in a position to enter into a legal binding contract with Living Social. The one issue that I might have with these terms is that most users, whether 18 or not, most likely aren't even aware that they're entering into any sort of binding documents with the company. Furthermore, Section 4 continues that users must not be banned from the site to use it. They may not use the site on behalf of someone who is banned, and they may not impersonate another user. I think that these terms are more than fair. Section 5 states that you must register to create an account to have access to deals and make purchases. You are responsible for providing correct information and keeping that information up to date. You are also responsible to make sure that only you use your account, and it's your responsibility to prevent unauthorized access from your account. Seems mostly fair, and at first glance only reiterates what was said in Section 4. However, at a closer analysis, it brings up an issue. If someone's computer or account is hacked, how can they then hold responsibility? In a situation like this, the user becomes a victim, not the perpetrator. And what about April 2013, where Living Social's database was breached and more than 50 million usernames and passwords were discovered by hackers? It is completely unreasonable to expect users to take fault for that, as Section 5 suggests. But Living Social does rectify its statement a little bit when it invites users to inform the company if they become aware that their login credentials are being used without authorization. Personally, I would waive any liability from the user completely if someone is using their account without their authorization, but at least an attempt to alert Living Social is given as an option. In addition, Living Social makes it a user's responsibility in Section 6 of its terms and conditions to read the fine print on the voucher. I cannot argue with the company there. As long as the fine print is there and visible when I buy the deal and written in layman's terms so that all customers can equally well understand it, I will read it before buying to know what I'm getting into. But like I've mentioned earlier, this is a pretty fair agreement and Living Social does make certain promises too. For example, Section 6 under refunds states that if you change your mind about anything that you bought before redeeming it, Living Social will issue refunds for that deal within 7 days of purchase. Living Social will also issue refunds for unredeemed vouchers if the merchant goes out of business before the promotional period expires. And if you have trouble redeeming your voucher with the merchant for any other reason, you may get in touch with Living Social at a provided email address, and the company will work with the merchant to resolve your issues and get you your deal. Seems very common sense, but having that clause in writing should be very comforting to the customer. Are there any other statements in the agreement that I think are unenforceable? Well, sure. For one, there is the termination clause in Section 15. It states, Living Social may at any time terminate this agreement with you if Living Social determines that the provisions of the services to you is no longer commercially viable. This part seems shamelessly self-interested and not realistic. This company cannot just stop providing services to a member because that one member somehow, without breaching his agreement, turns out not to be commercially viable for the company. That same section continues, and I quote, Without limiting any of the foregoing, Living Social may immediately terminate or suspend any user IDs, accounts, or passwords in the event that any conduct by you which Living Social, in its sole discretion, considers to be unacceptable. This statement is too broad and unrealistic. Any conduct that Living Social considers to be unacceptable, without ever even defining what unacceptable is. A better way of saying this would have been some conduct which violates any terms of this agreement or is deemed unacceptable by any section of this agreement. Then, at least, it is put in context and limits of this document so that any conduct becomes defined as conduct which violates this contract. Another statement which I don't believe should be enforceable in any section in Section 17, limitations of liability, where Living Social denies any liability for, and I quote, any claims for lost profits, lost data, loss of goodwill, work stoppage, computer failure or malfunction, or any other commercial damages or losses. And here's the punchline, even if we knew or should have known of the possibility of such damages. Now, Living Social did present this clause in all capital letters, making the clause conspicuous, hereby more likely to be enforceable in courts. And according to Walter Duke of Duke Law Offices, if drafted correctly, limitations of liability clauses are generally enforceable and enforced, even when they shift the risk from a potentially liable party to an innocent one. Fair or not? However, legally enforceable or not, I personally cannot come to terms with this clause. If the company was aware of a breach in their system and consciously failed to notify its users, hereby causing a damage to the user's system and hence irrevocable harm, how is that company not liable? They took no steps to stop the contamination, knowing in full conscience that others will be harmed. They should absolutely be held accountable. And why would the company put this clause here? Obviously to protect itself from any liability that might arise. There are three more clauses which I want to discuss, which all struck me as odd in one way or another. Section 11, your access to the sites and services clause, states that you're only permitted to link to Living Social's homepage, as in no deep linking. Seems fair, right? However, At a different sections of the terms and conditions, a user is actually encouraged to share deals that he bought via provided link. These deals, when linked to, do not go to the home page, but to the specific deal product page. So, in this this clause becomes contradictory and quite possibly unenforceable as well. Living Social does make a great point, however, in section 13, where it, and I quote, reserves the right but not the obligation to remove or edit user content, but does not regularly review posted user content. Living Social is protecting itself from any harm and potential defamation suits caused by user content by stating that it has no obligation and is not in the practice of reviewing such content regularly. In other words, it is saying that it is providing the platform for users to share comments, but it also gives itself the Communication Decency Act Section 230 type of protection by firmly stating that it is only providing the platform. Finally, Section 18 on arbitration struck me as very unusual for most companies, but also very kind to its users. Living Social here agrees to pay all arbitration fees, even if you, as the user, file the arbitration, up to $10,000. Also, arbitration may be held at the county most convenient to you. While from one side it is almost an invitation to drag Living Social to arbitration, it does make me wonder what gives? What is Living Social getting out of this clause other than the goodwill of its users? Well, I've done some research. According to Matthew Kirsner in Arbitration, Which Party Should Bear the Cost? Courts are subsidized by the taxpayers, arbitration is not. Upfront filing fees of $2,000 or more cause case arbitration administration fees and hourly fees for arbitrators can lead to a total bill in excess of the total of the claim and in excess of what an individual claimant can afford to pay. If the claimant must bear the cost but can't, the clause can then be seen as unfair and actually taken to court and be dismissed that arbitration is not an option precisely for the reason of cost. So, Living Social is taking the burden of the cost and the travel expenses, and by doing that, it is leveling the playing field, making arbitration overall enforceable, and hence avoiding jury trials or class action lawsuits, which could end up being a lot more expensive to the company than any arbitration would be. Well, I just touched on a whole lot in a short amount of time. I talked about the enforceability of Living Social's terms and conditions as a browse rep agreement, deciding that a more enforceable alternative would be to ask users to click on an agree button before using the site for the first time. I talked a lot about some of the responsibilities which users of the sites have according to this agreement, most of which are pretty fair. I also talked about Living Social's responsibilities, such as their refund policy, which is also pretty fair. However, Living Social also thought in certain clauses which might be or should be unenforceable, such as the termination clause and the limitations of liability clause. I also touched on the contradictory statements about deep linking into the website, user generated content, and the reason behind the seemingly gratuitous arbitration clause. At this time, the red flags have been raised. I am not a lawyer, nor do I have a legal background. However, it would be well advised for Living Social to look into and maybe rethink some of the points in its terms and conditions agreement, as well as it would be well advised for users of Living Social and any other website for that matter to carefully read the terms and services to know exactly what you're getting into. Thank you for your time, and this is Kira Portnaya signing off.